Yes, Mr. Havers. I can tell you that we have read the judgment of the court below, and we've read the scaleless arguments for which we are grateful, and we are therefore reasonably up to speed with what appear to be two fairly narrow issues.
That's very helpful. I suspect that your lordships are up to date, therefore, with the procedural background that brings this case before your lordship, so I need to say no more than that. And I anticipate your lordships already know what the representation of the parties on both sides is, so I'll dispense with that as well. Again, I anticipate your lordships may have had a chance to look at the 2008 Act sufficiently to understand the key sections of
Well, nevertheless, it's always helpful to be reminded.
Well, then, Lord, in that case, I will.
And gives you to make you. It gives you the opportunity to make any comments you wish to make.
Lord, the Act begins in the authorities bundle at page 2. The relevant sections for present purposes in this part of the Act are sections 3 and 4. And section 3 sets out the main objective of the CQC, and subsection 2 sets out the general purpose that lies behind its objective. And then section 4 sets out matters to which the Commission must have regard. In particular, I draw to your lordships and my ladies' attention little subsection 1, little e and little g, which I think then takes me to the two sections which are specifically in issue on this appeal, beginning at page 51, sections 60 and 61. Section 60, subsection 1 provides that the Commission may, for the purposes of its regulatory functions, carry out inspections of the carrying on of a regulated activity. So it's pursuant to that power that the appellant was inspected on the 17th of May last year. And then section 61, inspections carried out for registration purposes. Subsection 2, where an inspection is carried out under section 60 for the purposes of the Commission's functions under chapter 2, the Commission must A, prepare a report on the matters inspected, and B, without delay, send a copy of the report to 1, the person who carries on the regulated activity in question, and then subsection 3, the Commission must publish a report prepared under subsection 2. Well, those are the relevant provisions. There is no provision for any appeal from the report that, or the judgments, or indeed the ratings set out in the report provided by the Commission pursuant to those statutory provisions, and that's one of the factors that Mrs. Justice Andrews, as she then was, took into account when imposing a further layer of review in the SSP case, to which we will come presently. Lords, that's all I was proposing to say by way of introducing the appeal, save to add this. Of course, this is an appeal against the refusal of the judge below to grant permission to the applicant, the appellant, to claim judicial review on what were grounds 3 and 5, what are now grounds 1 and 2. So, strictly speaking, the issue before your lordships and my lady today is whether you should grant permission to the appellant to proceed on those two grounds. In other words, whether those two grounds are properly arguable.
Yes, we're not here to finally decide.
Well, no, that was the however I was about to go on to explain. On the 18th of January, those instructing me wrote to the Court of Appeal, inviting the court to at least consider whether to decide those issues for yourselves. And we set out briefly the grounds on which we we did invite the court to do so. Now, I appreciate that that would be an unusual course for this court to take. But what I was proposing to do was to make my submissions to your lordships and my lady first, and then at the end of those submissions to address the question whether this court should decide those issues for itself. They are both issues of some importance, general importance, to both the practice, and by which I mean the procedures followed by the CQC and its policy. There is now a difference of opinion between first instance judges as to precisely what Mrs. Justice Andrews meant by her additional layer of review, because your lordships and my lady will have seen that Mr. Justice Mostyn did not agree with the view taken certainly by Mr. Justice Holgate in Babylon, and he interpreted Mrs. Justice Andrews' decision as requiring something less than what...
Yes, indeed, and we'll be getting into that issue in a bit more detail in due course. But on the point that you've just raised, have you ascertained what the view of the CQC is?
Not I haven't yet, no.
But, I mean, certainly the question is whether these are arguable grounds. But if properly analysed, there is no unfairness, then they're not arguable. And to determine that, we will have to get into the merits of whether Mrs. Justice Andrews was what she meant and whether she was right to add on this additional layer. Because if she was right, or arguably right, then obviously they'll then go back to first instance.
Well, that would be the usual course of events,
yeah.
Indeed. But my submission, I prepared 4 submissions that fully argue the 2 grounds, so that by the time I've sat down, at any rate, I would have made submissions that would enable your lordships and my lady to decide those 2 grounds substantively if you chose to do so. And as I'm reading my own friend's skeleton argument, he and his junior plainly have done the same.
Yeah.
So, as I say, by the close of submissions today, this court will be sufficiently will be in a position to decide the grounds substantively if you choose to do so. There are other reasons for doing so, cost being one of them, convenience being another.
Well, and it's also apparent, because I couldn't chase what had happened to Mr. Justice Holgate's case, that inevitably, if one sends things back, they then might, because of good sense on both sides, sort themselves out, and the issue is then never resolved.
Well, that seems unlikely in relation to ground 1, given that the CQC sought to implement Mrs. Justice Andrews' decision by introducing a procedure different to what we say she had in mind. And that decision has received the imprimatur of Mr. Justice Mostyn, whereas we continue to argue, as Mr. Justice Holgate found, Mrs. Justice Andrews had in mind a different procedure.
Well, both Mr. Justice Holgate and Mr. Justice Mostyn were not finding, they were deciding what was arguable.
Well, I don't want to prolong this debate, but if one looks at, and I'll show you the relevant passages, Mr. Justice Mostyn in fact did decide the issue substantively. Yeah. He went further, simply saying it wasn't arguable.
Well, that's why I wonder whether it's very necessary to spend a lot of time deciding, whether we decide it substantively or not, because if it isn't a good legal point, then it's not arguable.
Lord, absolutely right. I mean, before I can invite your lordships to decide it substantively, I have to persuade you first that there is an arguable, that the 2 grounds are arguable. If I can't do that, then your lordships won't get on to the further question at all.
And Mr. Justice Holgate was saying that it is arguable that is what is meant and that he ought to follow it, etc.
My lord, well, we'll look at what he said.
Well, he said it in terms, and then he put it in the second sentence. He then said, well, in any event, it's arguable.
No, I think we would argue that he made it clear that what he thought Mrs. Justice Andrews had decided But Lord,
It was only deciding whether to grant permission to apply for judicial review.
well,
He wasn't making a final decision, so how can, I mean, what legal status has that decision got?
well, my lady, can we wait? Can I reply to your ladyship when
Sure.
we look at Mr. Justice Holgay's judgment? I'll have that in mind when we do so.
All right.
Very good. Okay, so you've told us about the substantive question. Where would you want to go from here?
Well, Lord, the first point to make on ground one is that very unexpectedly and without any prior notice, in its skeleton argument served last Wednesday, the respondent now submits that the law took a wrong turning with the decision of Mrs. Justice Andrews, that there should be an additional layer of review, and the respondent now submits that she was wrong to do so. That is apparent. I can invite you to turn up the respondent's skeleton argument. Go first to paragraph 61 on page 32. However, it is respectfully submitted that the law, in any event, took a wrong turning in SSP Health and imposed an unwarranted requirement of a second internal review, which was not justified by the statutory scheme nor by the common law requirement of procedural fairness. Then in paragraph 65 over the page, it follows that Mrs. Justice Andrews' judgment in SSP Health amounts to an unnecessary and unwarranted exercise in judicial legislation, imposing a two-tier review process when Parliament imposed no such requirement, and when the common law has not developed any such principle. And then over the page in paragraph 67, it follows that the debate in the authorities as to precisely what the independent review in the FAC process postulated in SSP Health should consist of is superfluous. There is no requirement in law for such an independent review. So, my own friend seeks to rewrite, as it were, the last 7 years and to submit to the court that Mrs. Justice Andrews took a wrong turning and that there is no fairness does not require, contrary to what she held, that there should be this additional layer of review. Lord, we submit that this new and unexpected submission can only be described as highly opportunistic. And I say that for these reasons. First, so far as we are aware, the respondent did not appeal or seek permission to appeal against Mrs. Justice Andrews' decision in SSP. Second, on the contrary, the respondent accepted her decision and changed its procedures in order to apply it as it has accepted. And I invite the court to turn back to its skeleton argument, paragraph 52 on page 30 of the core bundle. In the light of the decision in SSP Health, the CQC revised its procedures to reflect the terms of the judgment, and then it summarises the way in which they revised the procedures. And ultimately, thirdly, in neither of the two subsequent decisions of Babylon and Ideal Homes did the respondent suggest that Mrs. Justice Andrews had been wrong, or as it now puts it, that the law had taken a wrong turning. Can I ask you please to turn first to the Babylon case, which is in the authorities bundle at page 336. The report begins at the judgment begins at 309, But if I can ask you to go to paragraphs 81 and 83 and 82, page 323. Ground 1, this raises an issue as to whether the effect of the decision in the SSP case upon the process for checking direct and factual inaccuracies in a draft report has been lawfully carried into effect in the process undertaken by the Commissioner in this case. Defendant says that it's sufficient that an independent reviewer should contribute to the document responding to the service provider's comments before that document is issued, together with the final Section 61 report for publication, and before those documents are given to the service provider. But that's the procedure that the CQC has followed ever since SSP. On the other hand, the claimant says that that does not go far enough. They say that according to the judgment of Mr. Justice Andrews, it is necessary that the service provider should see the response of the inspection team. It can then ask for an independent review, and that review will separately indicate whether any additional changes should or should not be made. In other words, they say the two responses should not be conflated. I agree with the claimant that that was what was intended by Mrs. Justice Andrews as set out in unequivocal terms in paragraphs 57 to 60 of her judgment, and in the circumstances of that case. Well, that's why I said in answer to my Lord Justice Dingemans a little earlier that Mr. Justice Holgate appears in fact to have decided what Mrs. Justice Andrews meant. Accordingly,
he does go on straight away to say, accordingly, ground was arguable.
He does, but my Lord, it's the sentence before that
That goes back to my question. What's the status of Mr. Justice Holgate's judgment in circumstances where he was only deciding an application to apply for judicial review?
Well, the status is that since Mrs. Justice Andrews' decision, we have two decisions. I'll show you the next one in a moment. Two judgments of first instance judges, in which each expresses a clear view as to what Mrs. Justice Andrews meant by the additional layer of review that she said should be applied.
Yes, well, I understand the forensic point you're making, but first of all, her judgment is not a statute, and secondly, and in any event, of course, at first instance, judges of coordinate authority will naturally follow the prior decision unless convinced that it is wrong, and therefore it's only when the matter comes to this court that the correctness of that judgment can be considered.
Well, I readily accept what your Lordship puts to me. At the moment, I'm showing you these judgments in order to make good my observation that this new, unexpected argument by the CQC is opportunistic because it's never been raised before.
And in paragraph 27 of the judgment to which you're referring, Professor Gallagher had set out the changes they'd made.
Correct.
Yeah.
And your Lordship, my lady, will see from paragraph 82 that the CQC was not arguing in Babylon that Mrs. Justice Andrews had taken a wrong turning and that she should never have decided what she did in terms of what the requirements of fairness required. So that's Babylon. And then in the other cases, the ideal...
Can I just ask, before you get into ideal homes, just to clarify my understanding on one thing. The FAC process, is that doesn't appear to be in statute, or is it in the regulations?
So, the
FAC process.
No, Lord, it's entirely created by the
CQC to discharge what they considered was sufficient, and then we have Mrs. Justice Andrews' judgment. Great.
Correct.
That was my understanding. Sorry to interrupt, but I just wanted to confirm it was their process that they put together.
The process to be followed, the procedures to be followed, were entirely left by the statute to the CQC.
Yeah.
Although no doubt Parliament intended that
they would be fair.
They would be fair, exactly.
Yeah. Whatever that means.
Whatever that means. So, well, that takes me then to the ideal care homes case, which follows, beginning at page 336. Another first instance decision of Mrs. Justice Beverly Laing. And if your Lordships and my lady would please go to paragraph 16 at page 339. you will see that she said this. In SSP, Mrs. Justice Andrews held that procedural fairness required the defendant to undertake a review of its response to the proposed factual corrections to a draft report if the claimant so requested. The lead inspector was best placed to evaluate any factual comments made by the service provider in the first instance, but if a complaint was made about the response of the lead inspector, then an independent person within the defendant should conduct the interview. I think that must be a typo of the review as to the lead inspector's response. She also held that any comments by the service provider should be given full and frank consideration, and the report should be based upon accurate fact findings. So, again, no suggestion that the respondent to this appeal had argued in that case either that Mrs. Justice Andrews had taken a wrong turning.
There, can I just ask you this for you to address whenever you want? The bit that Mrs. Justice Laing rightly identified from Mrs. Justice Andrews' judgment was if the claimant so requested.
Yes.
And the CQC have not required the claimant to request, they've done an independent report. And just so that you can address it, your ground 3 below said our complaint is that there was no independent review, but the evidence, as I've read it, suggests that there was an independent review, it just wasn't at your request or after you'd looked at that. So first of all, is your ground sustainable at all because there was an independent review? And secondly, is Mrs. Justice Laing saying anything more than if the claimant so requested?
My Lord, our position has always been that what was missing in this case and what Mrs. Justice Andrews held should apply was an independent review of the response to the FACs and the final report, not an independent review carried out before the response and the final report were served. So,
sorry, an independent review of whose response to FACs?
The Commission, CQCs. Can I just explain the process?
No, I understand the process,
Yeah,
but they're two people's response is that the independent reviewer could be looking at either your response to the FACs or what the CQC has done to your response.
I understand. So I'm talking about the CQC's response to the FACs. And we've always been...
And do you say that's not happened?
That's not happened, no. Because, and the reason it hasn't happened, is because following Mrs. Justice Andrews' decision, the CQC decided that they could sufficiently comply with it by subjecting the draft response to an independent review before, well, in other words, whilst it was still being drafted, and before it was served on the service provider, not afterwards.
Yes, but there's two different points here. One point, which is the one you've just made, is you say that the procedure that's been adopted since SSP doesn't actually comply with SSP.
Correct.
But then there's a separate question, which is a more of a pleading point, which is what is your actual pleaded ground of objection, and whether that is sustained. Now, I don't think that the pleading point is one that's particularly being taken against you, but it's nevertheless one that my lord has picked up.
Only so that you can just identify.
Well, I'm not aware that we've ever suggested that there was never any independent review of this decision. But I stand to be corrected about that. Certainly, if we did, that's long since history, and certainly before Mr. Justice Mostyn, and since then on this appeal, the battleground has been clearly identified. We've always accepted that there was an independent review, but it took place before the response was served. Our case is that that's not good enough, because what's required is an independent review, if so requested, following the response, because the service provider may still have grievances about the response, which is served in response to the FACs, but has no opportunity under the CQC procedure to request an independent review of that response to the FACs. And I'm going to come to why we say there is an important detriment to service providers as a result.
Well, just to make the point clear, if we take the supplementary bundle part 1, tab 1, or statement of facts and grounds, and it's page 9 in the bundle, page 5 of the original document. And we see there, ground 3, defendant's failure to independently review its FAC response was procedurally unfair.
Yes.
Now, as thus articulated, the complaint is no independent review, whereas in fact that's not the complaint, because there was an independent review. Your complaint is it took place at the wrong time and in the wrong way.
Yes. Well, that if you want, you could go on, however, to paragraph 34. The point is expanded in the way that I've sought to articulate it. So what my Lord puts to me on page 9 of the bundle is a shorthand. It may not be the most elegant shorthand, but a short summary, as it were, of what is set out in more detail at paragraph 34, which I hope and believe does fully accord with the submission that we make to your lordships and that we made to Mr. Justice Mostyn below.
All right.
Lord, of course, there is a third point, in addition to the two that my Lord Justice Arnold put to me, which is that even if the CQC's procedure does not accord with what Mrs. Justice Andrews intended, is it still sufficiently fair to satisfy the requirements of fairness? And that's a point that arises in particular in this court, and I need to address that and propose to do so in due course. So, my Lord, you've probably got the point already that certainly in the cases that follow SSP, no suggestion that Mrs. Justice Andrews had taken a wrong turning. And then can I come to this particular case? In its statement of summary grounds of response, beginning at page 22, if I could ask you to go to page 36. And ordinarily this summary grounds of resistance stood as the respondent's skeleton for the hearing below. So, paragraph 52, ground 3, alleged lack of an independent review and procedural unfairness. There is no merit in this ground. The claimant has muddied the waters in the articulation of this claim. The claimant had a full opportunity to engage in the process, which included review by an independent person within the CQC in a manner that was fully compliant with SSP Health. So that was the position that was adopted by the respondent, not that Mrs. Justice Andrews had got it all wrong in SSP Health, as is now contended. And that remained the position in the respondent's supplementary skeleton argument before the judge below. And I ask you to go to page 60 in the same bundle. Paragraph 12, ground 3. This ground of challenge is unarguable for the reasons set out in paragraphs 52 to 57 of the skeleton argument. The process, I'm jumping a sentence, the process followed by the CQC is compliant with the judgment in SSP Health, and the same we find in paragraph 16 after setting out lengthy passages from Mrs. Justice Andrews' judgment. Paragraph 16 at page 62, the CQC revised its internal procedures in the light of the decision in SSP Health. Since 24th of August 2016, the replacement procedures have ensured, and then it's set out in summary form. This provided the procedural mechanism for safeguarding against an unfair refusal to make factual corrections which Mrs. Justice Andrews considered to be absent from the previous procedure. So their case clearly was not that she was wrong, they accepted that she was right, and this is how they've, as it were, carried into effect the additional layer of review that she said should be available, and their case was that what they've done is sufficient with what she intended. And Lord, in their submissions to Miss Justice Mostyn below, this argument wasn't raised at all. Lord, the appellant then applied for permission to appeal. And that was opposed, and in the respondent's response to the application for permission to appeal, we find this, and I ask you to go to the core bundle next, page 82. Paragraph 2, headed ground 3, procedural unfairness. So this is, we're now, as it were, in the appellate process. And this is their response to our application for permission to appeal. Ground 3 begins the response on this ground. In paragraph 3, the Lordship will see 4 or 5 lines. In this procedure, that's the procedure they have since adopted, was introduced following the decision in SSP, in which Mr. Justice Andrews concluded that there is an obligation on the CQC to carry out an independent review of a decision made in response to comments in the FAC on a request to do so by the inspected entity. 4, the CQC manifestly complied with the approach in SSP Health by undertaking a full independent review of the lead inspector's responses and so on. So again, not a hint of the new argument that's now raised on this appeal. Well, that argument was not raised until we received the CQC skeleton argument last Wednesday. There'd been no prior notification that it was to be raised. And my Lords and my Lady, that's why we say that raising the argument now can only reasonably be described as very opportunistic, and that is why we submit that your Lordships and my Lady should treat the argument with some circumspection.
I understand that point. Are you submitting that because Mr. Justice Mostyn did say, but if I have to say Mrs. Justice Andrews is wrong, it is wrong?
Yes.
Do you say that there's a need for a respondent's notice or not in the light of that additional passage?
Well, I'm not going to take that technicality.
No, although claimants and respondents in public law claims are told to have a bit more regard to pleadings than they might used to have done.
Yes.
No, thank you.
But Lord and my Lady, in any event, we submit that the argument is unsound and that Mrs. Justice Andrews' decision was correct for the reasons she gave. And in a sense, that is our submission on this point. But I develop it a little more, if I may. Before we look at what she said, may I remind your Lordships and my Lady briefly of 2 of the general principles of the common law duty of fairness in this context. First, the duty to act fairly, and in particular the requirements of procedural fairness, will readily be implied into a statutory framework, even when the legislation is silent and does not expressly require any particular procedure to be followed. Now, I anticipate that that principle will not be an issue between my learned friend and I. And if that is correct, I don't need to show your Lordships and my Lady what I have available to show you, which is simply the relevant passage from Miss Justice Fordham's current edition judicial review, but I can do so readily if necessary. It's on the
Well,
bench.
I think that's accepted by Mr. Stillitz in his skeleton argument, and it's not surprising. After all, that the argument that someone can behave unfairly just because the statute is silent is not an attractive one.
No, and the principle doesn't provide for the result, of course, or the outcome. But it's important because it emphasises the readiness of the courts to imply procedural fairness into a statutory framework, and to do so even when the statute is silent as to the procedure that should be followed. And of course that's the case here. This statute was entirely silent as to the procedure to be followed by the CQC.
Might the content of any such implied duty be influenced by the presence in other parts of the statute of detailed procedures dealing with this sort of issue?
My lady, in the right case, yes, it may be.
What I have in mind is the right to make representations in relation to a notice which is conferred by Section 27.
Lady, that is part of the registration, the provisions as to the procedure to be followed where a person applies for registration.
Yes, I'm aware of that.
Which is obviously a different.
Yes, I'm aware of that as well.
I'm sure your ladyship
So
is.
it's I'm making a more general
Yes.
point.
Well, my response to your ladyship's point would be that Parliament chose to make detailed provisions in relation to what an applicant for registration may or may not do by way of representations in that context, but left the procedure to be followed in relation to inspections entirely in the hands of the CQC, but must have intended, as my Lord Justice Dingemans pointed out a moment ago, must have intended that the procedure which the CQC choose to adopt must be a fair procedure.
Yes, well, one implies into the statute on the same basis as one implies a term into a contract. It's so obvious that it goes without saying. It's obvious that a regulatory body must act fairly. Doesn't need to be said.
So, Mr. Haywood, may I ask a follow-up question, please?
Yes, ma'am.
Parliament was clearly aware of the technique of imposing a detailed procedure for the making of representations, which is what Section 27 shows us. Should the court not therefore be cautious in imposing a detailed procedure on the CQC in circumstances when the statute is silent?
Lady, in my submission, no, the court would be in error in reading across, as it were, what your ladyship suggests could be read across in terms of what Parliament intended. What Parliament intended was, on the one hand, to lay down no procedure, to mandate no procedure at all to be followed in the case of inspections, but instead to lay down a detailed procedure as to registration.
Yeah.
And I would submit that all that shows is that Parliament took a deliberate decision to leave, not to say anything about the procedure to be adopted for inspections,
Yeah.
and to leave that entirely to the CQC, confident that the CQC would adopt a procedure that was fair.
Well, quite. So it's so obvious that it goes without saying that the regulator must act fairly, but it's not obvious, and therefore shouldn't be implied, that that requires any specific procedure.
Yes, ma'am.
So, therefore, it begins and ends with the requirement of fairness.
Correct. So the question is, what, in the context of this case, and cases like it, does the requirement of fairness require in terms of supplementing the procedure which the CQC have chosen to adopt so as to achieve fairness? And it's essential to bear in mind throughout that the procedure we're looking at is not Parliament's procedure, it is the procedure that the CQC have chosen to adopt. So
you've accepted, Mr Havers, that Parliament left it to the CQC to decide what was fair. And in that situation,
Lady, I don't think
by reference to what criteria should the court intervene?
Lady, I don't think I did concede that. What I conceded was that Parliament left it to the CQC to decide what procedure to adopt. But I don't think I've conceded, and I certainly didn't intend to concede, that Parliament left it to the CQC to decide what would be a fair procedure.
I see.
Because
Perhaps for the courts at the end.
for the court to decide.
Because this is a real issue, is what fairness will require.
Yes.
And what I think would be helpful to address when you're confronting it, whenever that may be, is obviously the authorities that Mr Stillitz has referred to, the old ones on what a report requires. You might also want to address the Inquiry Act and the Inquiries Act and the Inquiry Rule 13, which says if you're about to criticise someone, you have to give them a fair opportunity to respond to it. What it doesn't say, and so far as I'm aware, I'm not aware of any authorities that go this far, is say, once I've had your response, I then write up what I propose to say about that, and then give you a further opportunity to do that. I am aware that informally some people have done that, but it's never been formally required.
Lord, I am coming to those authorities, but just to, as it were, indicate briefly in advance, by way of a trailer, what I say, which is this, that those authorities were concerned, as my Lord rightly points out, with the question whether the court should ensure, as a matter of fairness, that someone who is or may be about to be criticised in a report has an opportunity to respond to those criticisms before the final decision is made by the inspectors or whoever and the report is published. That's what those cases were all about. None of them raised the point raised by Mrs. Justice Andrews for the obvious reason that the point never came up. So those authorities don't assist this court in determining that the new submission made by the respondent, which is whether Mrs. Justice Andrews took a wrong turning altogether. And
what's the distinction you're drawing? I'm not quite following.
Well, probably best to wait until we look at the cases, but the cases were all concerned with, as I say, the discrete point, whether someone who is to be criticised or may be criticised in a report should be entitled, as a matter of fairness, to respond to those criticisms before the report is published.
But why is that not the concern in our case? I mean, the concern of your client is that they've been criticised by the regulator. If they'd received an entirely glowing report, you wouldn't be here.
No, my Lord. Indeed not. Well, but their concern is slightly more nuanced than that. And of course, it's a concern that has to be fitted in some way to the procedure which the CQC have adopted to make provision for what your Lordship has just put to me. So the procedure that the CQC chose to adopt was to give the service provider an opportunity, I'm going to look at all the documents a bit later, I'm afraid, but to give them an opportunity to respond to concerns raised by the inspectors during the inspection, and to seek and to invite the Commission to correct any errors in the fact-finding exercise. The latter is to be done by the service provider putting in comments, the FACs, the factual accuracy check comments, to the CQC. The CQC then consider those comments and then prepare a response to them, which they send to the service provider at the same time as they send the final version of the report. So that's the procedure within which we are operating, because that's the procedure which the CQC have laid down. So that the question then for Mrs. Justice Andrews was whether fairness required the CQC to give the service provider an opportunity to ask for an independent review of that response and the final report before it was published. And that's the additional layer of review that she said should apply. And I can see I need to take the Lordship's Lady to her judgment and the reasons why she imposed it.
And also what happened on the facts of this case, because to be honest, all she said was you need to apply for it. She didn't say, and you have an opportunity to put in another 91 pages and 31 schedules.
And I'm not.
But what she did say was you have to have that opportunity. But here, as I understand it, the CQC say, and you may show they're wrong in this, that they short-circuited the requirement for a request. And once they'd worked out their response by the lead investigator, they then put it to the independent person in the CQC.
Well, that's what they say. They say that's sufficient. They say that complies with Mrs. Justice Andrews' decision, and so they say there's nothing to complain about. No, your Lordship is entirely correct.
And whenever in your submissions you can show why that isn't. That's, I think, your stage 2 bit to show that their procedure is not, in fact, what Mrs. Justice Andrews suggested.
Well, there are 2 stages. So many stages, I'm afraid, in this case, but my Lord is right, and then I need to explain why it makes a difference. And I'm going to seek to do
So we diverted you from what you were doing, which was setting out the basic principles you relied upon. So you said you had 2 principles of common law, but you've told us 1. What's the second?
The second is this, and this second one picks up the point that my Lord Justice Arnold was putting to me about the cases relied on by the respondent. Lord, it's this: the requirements of procedural fairness are variable and case specific. And again, that's unlikely to be an issue, but since it's in one of the authorities which are before your Lordships and my Lady in any event, can I take you please to the Shoesmith case that begins at page 253. I don't propose to spend time on the facts. It was the well-known case arising from the death of baby P, but in paragraph 33 at page 265, Lord Justice Morris K, halfway through the paragraph, said this: it is common ground that the requirements of procedural fairness are variable and case specific. Again, entirely uncontentious, I apprehend, but important in the current context, because it reinforces that there's no rule that one can apply across the board as to what the requirements of fairness may require in any particular case. What is needed is to look at the particular case in question and then to decide what the requirements of fairness
Well, there's a lurking ambiguity here which I'd like to flush out. The expression used in this judgment by Lord Justice Maurice Kay, which you have repeated, is case specific. But am I right in understanding that what he really meant there was context specific? In other words, in that case, he was dealing with Ofsted. Here we're dealing with the CQC. Yes. So specific to the context, not to the individual case.
Lord, I'd be content to substitute context for case.
Very good.
Because if it's case specific, it might undermine the idea that Mrs. Justice Andrews was deciding that there was a universal procedure for the CQC in every case.
Although,
well, don't worry, because you've adopted my lord's reformulation.
Yes. Although the practical effect of her decision has been for some years precisely that. Albeit that simply takes us back to the next issue, which is whether the CQC's procedure complies with what she intended. So, well, it's high time I turn to Mrs. Justice Andrews' judgment.
Very good.
And the reasons she gives for applying this extra layer of review. The judgment begins on. Can I assume that the Lordships and the lady have had a chance to read her judgment already?
Yes, we have.
Well, that's very helpful. Lord, in that case, can I take you at once to paragraph 52 at page 304. Now, this is the key part of the judgment for present purposes. Paragraphs 52 to 60. If your Lordships have already read these paragraphs, then I can take this part of my submissions rather more shortly, because the key paragraphs in terms of her reasoning are paragraphs 58 and 59. In 58 she says, if a complaint is made about the way in which the lead inspector has decided to respond to the comments, or about the failure to remove inaccurate fact findings, or to cure misleading impressions created by passages in the draft report, in my judgment it would place a disproportionate burden on the inspected party to require it to start proceedings for judicial review. It is well established that judicial review should be a course of last resort. Moreover, this court is generally an inappropriate place to resolve disputed issues of fact. Legal proceedings are time-consuming and costly for all concerned. Both the regulator and the regulated body will be subject to financial as well as time constraints.
Now, pausing there, would you accept that the language she uses in that paragraph is suggestive of a desire to be helpful and to suggest a pragmatic way forward, as opposed to stating what the law requires? Because, of course, if she were intending to be stating what the law requires, then the remedy would be one of judicial review.
Well, your Lordship says what the law requires. I mean, procedurally, absent the additional layer of review that she said should apply, that would have been the only option, as she makes clear, to the service provider, who is still dissatisfied with the response. But no, the question is what the common law principle of fairness required in this context. And she makes clear in paragraph 58 that effectively it would be unfair to require a claimant in circumstances where there is no right of appeal internally or for, can I go back to paragraph 55? there's no right of appeal internally. This is the line 5. It makes no provision for rights of appeal, this is the statute, against the review of ratings. And this is the submission, but that's the point. There is no right of appeal against or review of the ratings at that stage. So what in paragraph 58 she is saying is it's in those circumstances unfair to leave the service provider with no option but to commence expensive and time-consuming judicial review proceedings when an additional layer of review would provide a speedy and expert response to whatever grievance the service provider still has about the response and the report served by the CQC. And I pick up, therefore, the next paragraph, 59. On the other hand, an independent person within the CQC itself, applying common sense as well as his or her professional expertise, ought to be able to tell fairly swiftly whether there is or is not a legitimate grievance about the lead inspector's failure to correct the response.
May I ask you a question about that sentence? The phraseology seems to imply, although it doesn't state, that the lead inspector is not independent. But is that correct?
No, what?
Because the lead inspector is him or herself an independent person.
What she meant was that the lead inspector is not independent of any complaint made about the report, because the report is written by the lead inspector, as is the response. And the lead inspector, of course, took part in, indeed led the inspection.
So you would accept that insofar as the requirement for fairness brings with it a requirement of independence,
yes,
in fact, the CQC inherently satisfies that requirement to begin with because it is an independent statutory regulator.
My Lord, what I don't accept is that the lead inspector alone should decide on the response to the FACs and indeed on the report insofar as it deals with the FACs. What I submit is what Mrs. Justice Andrews held, which is that there should be someone else within the CQC independent of the lead inspector and her role.
To be sure, that's what she said.
Yes.
What I'm trying to understand is what the rationale is. Because the use of the word independence suggests that the rationale is that there's some unfairness in the lead inspector being required to consider the FACs and to make any corrections, and that unfairness needs to be remedied in some way because there's a lack of independence. And what I'm trying to understand is what your submission is as to wherein the unfairness lies.
Well, Lord, it's a bit like the lead inspector marking her own homework. And what I say is that someone, albeit from within the same organisation, but someone independent of the lead inspector should review the lead inspectors.
So you're not asking for institutional independence.
Nope.
So what therefore is the connotation of independence in this context?
Someone who is independent of the lead inspector and in particular her role in the inspection and her response, her own response to complaints about her own inspection. Which is why I say she would otherwise be marking her own homework. And can I just, it's illuminating, we submit.
And an obligation of that detailed character is to be implied into the statute, is it?
Well, lady, it's to be, the statute is to be supplemented so as to ensure that the lead inspector's response is reviewed by someone independent of the lead inspector for the reasons that Mrs. Justice Andrews gave. But I'm at risk.
I mean, the phraseology of marking your own homework is forensically appealing. But what I'm trying to understand is what the intellectual underpinnings of it are. Because as soon as you move away from institutional independence, I question what the word independence means. So, let's take two hypothetical examples. Firstly, the so-called independent reviewer is junior within the organisation to the lead inspector. Would that meet a requirement of independence?
Well, probably not, but it's unlikely, I would suggest, that that is going to be the case, and certainly it hasn't been suggested in the present case.
Suppose then that the so-called independent reviewer is the line manager of the lead inspector. Is that sufficient?
Probably not.
Right. So, in truth, you are arguing for something that, although you disclaim a requirement of institutional independence, has some character of institutional independence.
All I'm arguing for is that the review is that first there should be, and the first question is, I suppose, should there be a review of the response and the final report? And the second is whether that review should be carried out by someone independent in the sense that I've articulated. And it's important to remember that the CQC have accepted all this since Mrs. Justice Andrews' judgment.
But as if you told us they no longer accept it in this court.
But now no longer accepted. But up until now, they've accepted this and have independent.
What I'm still trying to ascertain is what your submission is as to the criterion of independence, because what you've told us is that a subordinate is not independent and a line manager is not independent. So therefore, what is the criterion of independence?
Well, Lord, can I try to answer that by showing your Lordship a page from the supplementary bundle, if your Lordship could just give me a moment. Yes, if I could ask you, please, to go to page 382 in the supplementary bundle. This is part of a document that begins at page 372, headed Factual Accuracy Check, and is much relied upon by the respondent in relation to ground 2. But if I could ask you, please, to go to page 381, section headed Factual Accuracy Check, How We Will Respond. You will see at the top of page 382, second paragraph, all factual accuracy responses will be reviewed by another member of CQC staff from the relevant inspection directorate, who is authorised to sign off the related inspection report. This member of staff will be independent of the original site visit. Now that's how CQC define independence in this context.
Seems to me to entirely beg the question. And you see, this only becomes relevant if there's a legal requirement. Because if there is no legal requirement, then it doesn't matter, because the CQC is the judge of its own procedure.
Yes. Well, Lord, the first, can I break down the legal requirement into 2 stages? Get more stages, I'm afraid. But the first stage is a review of the response to the FACs required, if so requested, following service of the FAC response? That's the first question. And we say yes for the reasons I've already submitted. The next question, which is a separate question, is if so, who should carry out that review? Now, Mr. Justice Andrews' answer to that was someone independent of the original inspection. And that, we submit, is a sensible and obviously workable answer. See the procedure as set out on page 382 of the bundle.
Well, except that if we read what's put on page 382, then the member of staff independent of the original site visit could be a subordinate, it could be a line manager.
No, it could.
But you've just submitted that neither of those would be truly independent.
Well, Lord, if one is going to aim for as much independence as possible in terms of the person who carries out the review, then it would be desirable that the person who carries it out isn't neither one nor the other. It'd be interesting to hear from Mr. Stillitz, who in fact, in terms of status and position in the company, in the commission, actually carries out these reviews. And it may well turn out to be the case that it is someone regularly who is more senior than the lead inspector and someone who isn't his or her line manager.
But so what's your submission? I'm sort of struggling to understand whether you're retreating from your earlier answers or whether you're maintaining them.
Well, Lord, I said probably in my earlier answers, because I was searching for a workable nature of independence. But if the reality is that whoever carries out these reviews is routinely more senior to and not the line manager of the lead inspector, then my Lord of Justice Arnold's point in practice isn't going to create a difficulty.
May I just ask you one question on your first? You broke that down into two stages, yes. Which is there a legal requirement for a review of the FACs? And you said yes for the reasons submitted. And the reasons you submitted were picking up Mrs. Justice Andrews to avoid the costs of a judicial review, which are a burden. Were there any other reasons?
Well, Lord, can I just go back to her?
Well, yes, because I think it is important, because what I'm then going to ask you is why, if you go to the CQC, do you do better than anyone in a public inquiry? Because the inquiry chair marks their own homework, ad hoc inquiries, and so what I want are your reasons and why people in front of CQC do better.
Well, can I take you back to Mr.
Of course,
Justice
yes,
Andrews?
yeah.
Because that's where my submissions are founded. So paragraph 58, which I've read to you already, the disproportionate burden on the inspected party to require it to start proceedings for judicial review. Yeah. If there is some simple, speedy and non-costly alternative to that, which in the context of this case and these cases, there is, she held, namely a review by an independent person within the body of the response to the FACs. So that's also a key part of her reasons, and that's context specific.
Yep.
And she went on in paragraph 59 to explain how that could be done swiftly. She expressly says 7 to 14 days, and we would readily accept that the CQC could insist on a request being made, a request for such a review being made within, say, 7 days.
Well, that doesn't give you a timescale of 7 to 14 days,
No.
unless they respond immediately, which is hardly fair.
No, I'm so sorry. The request from the service provider for a review should be made within 7 days of receipt of the FAC response. And if the CQC wished to do so, no doubt they could reasonably limit the representations to be made by the service provider to...
So you want to make representations? I thought you accepted Mrs. Justice Andrews had just requested a review.
Well, there would have to be... Right,
so you're saying that when Mrs. Justice Andrews said on request, what she meant was together with a whole series of further representations?
No, I was going to restrict them by saying, and I'll look again in a moment at what she actually says.
Yeah.
But restrict, be entirely reasonable for the CQC to restrict the amount of representations made to 2 or 3 pages of A4 or whatever the electronic equivalent is. But my Lord, there's not much point in a service provider requesting a review without more. That's not much help to the reviewer. It only makes sense if the service provider who requests a review indicates briefly what his grievances are or why he complains about the response.
And that may assist in working out what Mrs. Justice Andrews originally intended.
Well, I think it
because
will.
She didn't put in, and you must have the opportunity to make further submissions. You say it's implicit.
I do. I think if one goes to... Yes, no, I do say it's implicit. I mean,
well, you have to say it's implicit because it's not spelled out.
I was just looking at the final paragraph.
No, I've read it carefully, right? As have you, as has Mrs.
Yes,
Stills.
yes. Well, my short answer is giving the service provider that opportunity is of little assistance if the service provider can't indicate to the reviewer why he says that the response is inadequate. And indeed, the service reviewer won't be much assisted. The reviewer won't be much assisted if he simply asked, or she is simply asked to review the decision. He's going to be much more assisted if there's a page or two of reasons why the service provider says that the response is inadequate. So, yes, implicit, but B, unnecessary for her to have spelt it up because it is so obvious, I would submit.
Thank you.
So we also need to take into account what she said in paragraph 69, where she says, I will therefore grant a declaration that there is an obligation on the CQC to carry out an independent review of a decision made in response to comments in the FAC log on a request to do so by the inspected entity if the ground of complaint is that a fact-finding maintained in the draft report is demonstrably wrong or misleading.
Well, I'm grateful to my Lord for pointing out that paragraph, because that does, in my submission, make it clear that she had in mind that the service provider would be able to provide some representations along with the request for a further review, because how else could the service provider make the complaint that the report was demonstrably wrong or misleading? I mean, it would be pointless if the service provider couldn't set out briefly the respects in which he or she so contended.
Well, I think Mrs. Justice Andrews took the view in that case that there had been confirmation bias by the report writer, who had been not told about a policy for the over 75s, pointed out there was a policy, But instead of then rewriting it, well, the important person, the practice manager, who should have known of the policy, didn't know the policy, and there was a policy, just wrote, there is no policy.
Yes.
But that's obvious. You don't need further representations to point that out if you are truly independent of the process and not operating with confirmation bias.
Well, you know, absent any representations from the service provider, the if you pardon the poor old reviewer is going to have to trawl through the whole response to the FACs and all the FACs just to double check whether there is some obvious error. That's not a, we would submit, that's not a productive use of his or her time. Much better that he is alerted to whatever complaints the service provider has about the response, whatever inaccuracies or unfair impressions he or she says the report creates.
But I'm not sure I quite follow that. So, as my lord has pointed out, the complaints in this case, SSP, were actually very simple ones, and they can be summarised in the familiar proposition that absence of evidence is not evidence of absence. Now, that's a point that needs to be made once, doesn't need to be repeated. So, what is gained by giving the service provider the opportunity to repeat that point?
Well, Lord, I can explain. Following the service of the report in this case and the FAC response, judicial review proceedings, because there was no review available, were in due course, in fact, very soon afterwards, launched. The speed with which they were launched was stated by the date when the CQC proposed to publish the report. Those proceedings included complaints about the factual accuracy or otherwise of the report. In parallel with the progress of the judicial review, discussions took place between the parties, which in due course resulted in the CQC amending the report before they published it in a number of respects, because they accepted that the report which they had originally proposed to us, the final report, was defective and inaccurate in those respects. I'll show you, Lordship, my lady, now the covering letter to the published report, which sets that out. So this case is itself a very good example of what a review of the FAC response and the report can achieve, and why depriving the service provider of that opportunity of a further review has the potential to have serious adverse consequences for the service provider. Can I just we don't have an usher or an associate. Lord, in front of your lordships, would your lordships allow me to do the honours? I'm so sorry. Oh, hang on, it's the separate there. That's not it. This one is January. No, it isn't. Is it in the bottom? Yep. My lady, if you would go to tab 2, you will see the letter which accompanied the published report. And it says in the second paragraph, the final report includes a small number of changes following the without prejudice communication between the parties. Further to those communications, the CQC has made a number of minor amendments to the report. The changes are set out in bold. The changes are to correct minor factual inaccuracies and other obvious errors, and then they helpfully set them out in the letter. And although I'm not suggesting your Lordships and Lady should do this, if you look at the published report, you will find that they are there indeed in the published, the final version of the report. Now, there may be an argument about the effect of the significance of these changes to the final report, but that's not an argument for today. The fact is that the final report, the published report, was changed following effectively a review by the CQC of the final response and the final report served back last October. And thus we do submit that there is a real point of substance here and a real benefit to a service provider from being provided with this additional layer of review.
So this letter was it sent after an exchange of pre-action protocol correspondence or after proceedings were begun?
It was sent after proceedings, indeed 2 months after the hearing for Mr. Justice Mostyn. If my lady goes to the...
That's all right, I don't need to see it,
Okay.
I'll take it from you. So it was sent 2 months after the hearing for Mr. Justice Mostyn.
I think discussions have been going on in the meantime between the parties.
Yeah, well, there's a reference to without prejudice.
Yes.
All right.
So, if I can just, as it were, wind up what I wanted to say about Mrs. Can I take you back to Mrs. Justice Andrews' judgment, which I hope you've still got open in front of you. The only points I'd add from paragraph 59 are what she says about a short delay for the independent review. She said at the very bottom of the page, against that background, delay in publication of a further week or fortnight whilst the 4 specific grievances were considered would not be disproportionate or cause undue damage to the public interest. And
well, the background is quite important, though, isn't it? It's that the inspection took place in November and the report wasn't published until March.
and that's,
So a period of nearly, I don't know, 6 months or something.
and lady, that's the case in the present case. The inspection took place in May of last year, and the final report and the response were served in October. So a short further delay, whilst the appellant's grievances were considered by the reviewer, would not have been disproportionate and would not have caused undue damage to the public interest. So we would submit.
Is that the last point you're going to make on this judgment?
Can I just turn up my note and
Sure.
check whether it is?
It's just I'd like to ask you a question about it when
Of course.
we're finished.
Lady, it's not, because I do need just to look briefly at the authorities relied upon on this part of the case by the learned friend Pergamon Press and so on, but I can do that really quite shortly.
Well, sorry, my question relates to this judgment specifically.
Right.
So
That
convenient
I have
for me
otherwise
to ask
finished with it, yes.
Yeah, all right. If one looks at paragraphs 61 and following of the judgment, it's clear that Mrs. Justice Andrews dismissed the claim for judicial review as pleaded. See paragraph 67.
Yes.
She goes on to say she's accepted that the claimant has a legitimate grievance. Paragraph 68, she says, I would have granted judicial review and quashed the lead inspector's decision to maintain blah, blah, blah. But that wasn't the decision that was actually challenged. Had that been the decision challenged?
Yes.
And then she goes on to say she's going to grant a declaration.
Yes.
What is the status of the declaration? I mean, isn't it obit a relief? Because she's dismissed the pleaded claim. I'm slightly struggling to understand what's going on.
Well, look, if your relationship picks up the opening of paragraph 69, what seems to have happened is that the real issue, as she called it, emerged during the course of argument before her.
Yeah, I've read it.
Yes. And so that ultimately was the issue which she had to determine. And that was the issue.
Did she? Because it wasn't pleaded, and it doesn't appear from this reasoning that the claim was ever amended. So she dismissed the pleaded claim, and this is all conditional. I would have granted judicial review of, had that been the decision challenged.
Well, Melanie, that was in relation to the claim for judicial review of the decision in question. But lady, it doesn't follow that she then went on to grant a declaration. I know your ladyship has read paragraph 69.
Yes.
But in order to resolve the real issue which emerged during the course of the hearing, she granted a declaration.
Yes, but it wasn't a pleaded issue, and
Does that,
she didn't grant an application for judicial review. So that's why I'm struggling with how she's able to grant the relief described in paragraph 69.
well, lady, the pleading points that your ladyship now takes weren't raised, obviously, by the defendant to object to
they're not
her.
pleading points. They're mentioned by the judge. The judge said the claim as pleaded must fail. Paragraph 67.
Yes. Well, as currently formulated.
And then paragraph 68 is expressed hypothetically. I would have had that decision been challenged.
Well, lady, she obviously still considered that there remained an issue to be determined.
Right.
She determined it, and she granted a declaration accordingly.
I see. All right.
And as I've said, the CQC didn't appeal against the grant of that declaration.
Yes.
They were
You've made that point.
So can I then turn briefly to look at the authorities that the respondent relies upon? Can I take you to its skeleton argument, beginning at paragraph 40, page 26 of the core bundle. And would your lordships and lady please turn up Bergen Press, which begins at page 88. And go to page 99 of the authorities bundle to pick up the key passages. Just below D, Lord Denning said, I cannot accept Mr. Fay's submission. It's true, of course, that the inspectors are not a court of law. Their proceedings are not judicial proceedings. They are not even quasi-judicial. But they decide nothing, they determine nothing. They only investigate and report. They sit in private and are not entitled to admit the public to their meetings. They do not even decide whether there's a prima facie case, as was done in Wiseman. But this should not lead us to minimise the significance of their task. They have to make a report which may have wide repercussions. They may, if they think fit, make findings of fact which are very damaging to those whom they name. They may accuse some, they may condemn others. They may ruin reputations or careers. Their report may lead to judicial proceedings. It may expose persons to criminal prosecutions or to civil actions. It may bring about the winding up of the company and be used itself as material for the winding up. And I pick it up just above H. Seeing that their work and their report may lead to such consequences, I'm clearly of the opinion that the inspectors must act fairly. So that's what led Lord Denning to conclude that fairness applied. This is a duty which rests on them, even though they are not judicial nor quasi-judicial, but only administrators. The inspectors can obtain information any way they think best. Before they condemn or criticise a man, they must give him a fair opportunity for correcting or contradicting what is said against him. They need not quote chapter and verse. An outline of the charge will usually suffice. That is what the inspectors here propose to do. But the directors of the company want more. They want to see the transcripts of the witnesses who speak adversely of them, to see any documents which may be used against them. They or some of them even claim to cross-examine the witnesses. In all this, the directors go too far. This investigation is ordered in the public interest. It should not be impeded by measures of this kind. So, my lords and my ladies, the issue...
What do you say about the passage at F to G, where he addresses the suggestion that the inspectors should give the party in question the opportunity to comment on a draft of the proposed passage of the report?
Yeah.
And he rejects that,
Yes.
and he says this sort of thing should be left to the discretion of the inspectors. They must be masters of their own procedure. They should be subject to no rules save this. They must be fair. So he said it was not even a requirement to show them a draft.
Well, Lord, that things moved on thereafter with Maxwell and the Maxwellisation process that followed Maxwell. And now they are shown a draft of the proposed criticisms and given the opportunity to...
Well, you'll have to make that good, because that's not what happens under the inquiries rules.
Right.
Ad hoc inquiries never did. The whole Maxwellisation process got ditched because it was very ornate, was great for lawyers. You know, some of us may even have been beneficiaries of it, but it was not necessary, and the inquiry rules require giving notice. So you're quite right, things did move on,
Yes.
but things have moved back, and you will need to make good the proposition that they should have stayed when moved on and not moved back.
But my lord, they moved back because of the inquiry rules that came into...
No, ad hoc inquiries, the Hutton inquiry, for example, adopted a process which was governed only by common law fairness and never challenged, and the inquiry rules were then based on that process.
Thank you for correcting me, my lord. But as always, the only question is fairness. What does fairness require?
Exactly.
Of in the context in question, and that's, I mean, my Lord Justice Arnold just read to me the passage between F and G. They must be masters of their own procedure. They should be subject to no rules save this. They must be fair. Now, the rules that the inspectors in Pergamon Press, or the commissioners in Pergamon Press, had adopted were not fair, say it was found by the Court of Appeal. And they were not fair because they didn't provide an opportunity to the person who may be criticised to...
Did they find it wasn't fair in this? Look at the head note, page 389. Sorry, I mean, you may be right.
Yeah, but I may... No, I think your Lordship, I'm sure, is correct.
I certainly wouldn't guarantee it, but it's just, I'm just looking at the head note.
What? And it's
No, your Lordship is, I'm so sorry, your Lordship is correct. The question was whether they were bound to go further than simply to give the those potentially subject to criticism an opportunity to respond to those potential criticisms. I stand corrected. But my point is that the issue in that case was context specific, and was whether the commissioners should go further than that and should allow the inspectors should allow the directors of the company to see transcripts of witnesses and so on. So that was the debate. That's what the argument was about, which is very different to the argument in the present case.
Well, the passage my lord's referred to is spot on. They should see the draft proposed passage and be entitled to comment on it. Because you're saying we should read into Mrs. Justice Andrews' judgment that which she didn't expressly say, namely that there should be a right to make further representations on the proposed response to your FACs.
And I've sought to answer your Lordship's point already by saying that simply asking for a further review isn't going to be much help to anyone unless the service provider can indicate why he's asking for a further review. Indeed, I'm sorry to go back to her judgment
Of course.
again, but it's page 305 in the same bundle. At the foot of the page, in 4 lines up, in this case the CQC did not publish the report until March 2015, even though the inspection took place the previous November. It had good reasons for doing so, but against that background, the delay in publication for a further week or fortnight, whilst the 4 specific grievances were considered, would not be disproportionate. So she obviously envisaged that when requesting a review, the service provider would identify whatever grievances it had about the response, the FAC response, and the report. And just going back then to page 99, one of the factors which led Lord Denning to conclude that there was a duty to notify or give those who may be subject to criticism an opportunity to correct or contradict what is said against them, was the consequences of the comments or criticisms that the inspectors may then make in their report. That's what's set out at some length in the paragraph beginning just above the letter F. And of course that's part of Mrs. Justice Andrews' reasoning. The consequences for the service provider of a report that is still factually incorrect, notwithstanding that the CQC has considered the FACs, may be very serious for obvious reasons. And going back to the passage at page 100, just below letter B, another of the reasons why Lord Denning refused to go further was that the investigation ought not to be impeded by measures of this kind. Well, it hasn't been suggested, nor could it be by the CQC, that applying an independent review of the FAC response will impede or can impede its investigations. On the contrary, it has itself introduced such an independent review, the only question being whether it complies with what Mrs. Justice Andrews intended. Lords and my Lady, Hoffman-La Roche is the next authority. Again, I don't think I need to turn this up. The passage cited in paragraph 42 of the Respondent's skeleton argument represents a general statement of what the duty of fairness required of the members of the Monopolies Commission when carrying out an investigation in the context of the appellant's contention that the Commission have failed to follow those rules or comply with that duty. That the point made by Mrs. Justice Andrews simply didn't arise, and Lord Diplock never suggested, unsurprisingly, that the principle of fairness did not extend any further. Again, we're back to the context-specific question: what does fairness require in any particular case? Shoesmith, paragraph 44, is cited to suggest that Ofsted's duty of fairness did not extend as far as the full rigours of maximisation. Can I just show you briefly a passage not cited in paragraph 44? The report begins at page 253, and in paragraph 37, when considering what procedural fairness required of Ofsted, which begins at paragraph 30, paragraph 37, Lord Justice Moy's case said the judge referred to the unique nature of the inspection. In my view, he was justified in so doing. Having regard to all the features I've mentioned, I do not consider that he erred in interpreting the common law requirements of procedural fairness as he did. And those features are set out beginning at paragraph 30. This was not a disciplinary procedure, not targeted at individuals, a general review of how the system worked as a whole. And thus he held that the full extent of the duty that he held did apply to the Secretary of State did not apply to Ofsted, again, because of the context, because of the nature of the investigation, because of the specific circumstances of the case.
Where's the authority for the proposition that you had to send a draft of the report to a party to comment on it? Because you don't get that from the Maxwell authority. I know it's referred to as Maxwellisation.
Yes.
And a practice grew up after Maxwell of doing that.
Yes.
But the court specifically said there was no duty to do that.
Yes. Can I pass on your?
Yeah, no, sorry to ask.
Answer it later. I mean, I remember taking part myself in inquiries where precisely that procedure was followed, and it was thought that it had to be followed. But as your Lordship points out, that's no longer the case.
Well, but also, I'm not sure it ever was the case, probably understood, because if you look at Maxwell, Divider 4, that wasn't the result of Maxwell. No,
that's an interesting topic, but can I swerve around it?
Oh, of course, and I'm sorry to ask the question.
Thank you very much. So, my Lord, as your Lordships have seen, and my Lady has seen, these authorities, I'm not going to take time with Clegg, were concerned with ensuring that a person whom it was proposed to criticise in some way has the opportunity to respond to those criticisms. It doesn't follow, therefore, that Mrs. Justice Andrews was wrong in the context of the CQC's procedure to hold that a further layer of review was required for the reasons that she gave. And I've made more than enough submissions as to why we say those reasons were well founded. I'd only add that it's striking that in its skeleton argument the respondent doesn't address her reasons at all, simply submits that she took a wrong turning in law. Lords, that takes me, that's all I want to say about the new submission. And that takes me to what we had always understood would be the true issue on ground one, which was firstly what Mrs. Justice Andrews meant by the additional layer of review, which she held should be provided. So I'm afraid it's back to SSP. And can I ask you to go first to paragraph 56 on page 305. And lines, it's the passage beginning about 8 lines down, as this case demonstrates. Circumstances may arise in which there is a legitimate complaint about the failure by the CQC to change the draft in response to those suggestions. In order to be fair, there ought to be an effective process for resolving such complaints swiftly and fairly. It must be robust enough to ensure that legitimate complaints will be upheld. At the same time, a body which is rightly made the subject of censure should not be able to put off publication by raising spurious complaints. So that passage begins, as this case demonstrates, circumstances may arise in which there is a legitimate complaint about the failure by the CQC to change the draft in response to those suggestions. And this is the draft of the report. Next, paragraph 58, lines 1 to 5. If a complaint is made about the way in which the lead inspector has decided to respond to the comments, now that can only be a reference to a complaint about the response to the FACs. So what she's addressing there is if the response is served on the service provider still complains about the response. And she goes on, or about the failure to remove inaccurate fact findings or to cure misleading impressions created by passages in the draft report. In my judgment, it would place a disproportionate burden, and so on. So she is plainly addressing the position post-service of the CQC's response to the FACs. Paragraph 59, first 4 lines. On the other hand, an independent person within the CQC itself, applying common sense as well as his or her professional expertise, ought to be able to tell fairly swiftly whether there is or is not a legitimate grievance about the lead inspector's failure to correct the report. Now, that can only be a reference to, again, the draft, but not the draft, the response served to the FACs, because that's the first and only occasion that the service provider will be able to see what is the response of the lead inspector to the FACs and to see whether there is still a legitimate grievance about that response. And then finally, paragraph 60, which I know you've all read at length many times.
But there's also, sorry to interrupt you, Mr. Davis, there's also the passage you've already shown us at the foot of page 305.
Yeah, I'm grateful to you, ladies. Yes, correct. And then paragraph 60, I therefore conclude that in this case, procedural fairness required the CQC to undertake a review of its response to the proposed factual corrections to the draft report. In other words, a review of its response to the FAC. So that's why we submit. I'll go back to his judgment in a moment. Mr. Justice Holgate was correct to say that it's unequivocal what Mrs. Justice Andrews intended. Not that there should be some independent review or input before or whilst the response was being drafted, but that there should be an independent review following service of the response and the report on the service provider if the service provider so requested. But one might add, how could the service provider so request such a review if the review had taken place before the response and the final response and the report was heard? So, in our submission, her own judgment makes it clear that that's the time, that's the stage at which she was addressing. And I go back, therefore, to Mr. Justice Holgate in Babylon. It's the next authority. We've looked at it already, page 323. And in paragraph 82, he set out the competing contentions. In 83, he said that he agreed with what was intended by Mrs. Justice Andrews, as has been pointed out, then went on to say, because this was the full extent of what he was being asked to decide, at the very least, ground one is arguable. And then Mrs. Justice Laing, and I've shown you this paragraph already.
Sorry to interrupt, just before we leave Babylon. So
Yes.
and that must have settled after this bit, because I couldn't see that it had been reported anywhere else.
My Lord, I believe that is the case. I was in Babylon.
I could see that. Yeah. Okay, thank you.
And then Mrs. Justice Beverly Laing in Ideal Care Homes, page 339.
And she was just dealing with the injunction here, not even the grant of permission.
Yes, but her understanding,
Yeah.
a clear understanding of what Miss Justice Andrews decided, was that she decided that a review was required of the response to the FACs.
Well, her decision at paragraph 42 was that there was no arguable public law error.
Yes, and indeed, what's striking about paragraph 16 is that it wasn't even being suggested in Ideal Care Homes that what Mrs. Justice Andrews actually intended was that the procedure should be one that, sorry, let me rephrase it, that the procedure in fact adopted by the CQC was compliant with what she intended. But
what do you say about paragraph 44? Saying that the defendant was not required to draft its report a particular way, and giving reasons for accepting or not accepting criticism by the claimant, and if that was what Mrs. Justice Andrews said in SSP, then she disagreed.
Well, it's not clear to me at any rate exactly what she's addressing there. Having correctly, in paragraph 16, set out what Mrs. Justice Andrews had intended.
Well, maybe she's dealing with a further point, which is an argument that the final published report should record the claimant's criticisms of the draft and give reasons for accepting or not accepting them. I mean, I don't know.
Maybe I'm not sure I can say yes or no to that.
Well, because she says the defendant was not required to draft its report.
Yes, your notice, right, yes.
And
Yes.
Justice Laing is quite right. Mrs. Justice Andrews had nothing to say about it.
No, she did not. No, I accept that. So, until Mr. Justice Mostyn's judgment in the present case, there seems to have been agreement between the first instance judges who had to consider this question, or who did consider it, as to what Mrs. Justice Andrews meant.
Well, what can we get from paragraph 16? Because one of the points you made about paragraph 16 of Mrs. Justice Laing's judgment was that none of this was in dispute at that stage.
None of this. Well, the first point I made was that the CQC did not, in ideal home suggests that Mrs. Justice Andrews has taken a wrong turning in the law.
No.
Second point I make is that she describes what Mrs. Justice Andrews intended by way of further.
Was there? My point is, was there any argument?
It doesn't seem. I hope I said this a moment ago. It doesn't seem as though the CQC took issue with that.
Right.
There was an argument about it.
Okay.
I agree.
And it doesn't seem as if the claimant said, look, the first failure the CQC have done is not to implement Mrs. Justice Andrews' report. I mean, it just seems to have been unsatisfactory for lots of different ways. I'm not sure we can take very much from it.
Probably not, save that Mrs. Justice Beverly Laing read the judgment of Mrs. Justice Andrews in the way in which we submit it should be read. So, with that rather lengthy introduction, can I take you to the judgment below? But with one eye on the clock, can I deal with this quite briefly? Because I know your Lordships, my lady, would have read it with some care. Effectively, Mr. Justice Mostyn did not accept that the CQC's procedure, independent review during the drafting of the response, no review after the response has been served. He did not expect. He did not consider that was necessarily inconsistent with what Mrs. Justice Andrews had held, and if it was, then he respectfully declined to follow her. I can give your Lordships and my lady the references, but I suspect that's not going to assist you were I to do so. If we're right about what Mrs. Justice Andrews said and what she intended by way of a additional layer of review, then in my submission it follows that Mr. Justice Mostyn was wrong in that respect. Just looking ahead.
Well, what about his reasons for declining to follow her if he was wrong about the legal point?
Yes, I'm just about to come to this.
Oh, okay, I'm so sorry.
But it's perhaps worth noting that he went further than simply saying not arguable, because in paragraph 33, he held that the procedure adopted by the CQC is fair and therefore lawful. Now, so far as the reasons that he gave are concerned, first he said that the CQC's procedure is considerably shorter and more condensed. Paragraphs 25, 28, 30, 31 and 32. Take time showing them to the court. We say no. First, as to the independent review, the only difference between the two procedures is the stage at which it takes place. Under the CQC's procedure, it takes place during the drafting of the response and before the response is served. Under Mrs. Justice Andrews' procedure, it takes place after the response has been served, and only if a review is requested. So there may be cases where there's no review required to be carried out at all.
You're missing out your submission that once you've got back the lead inspector's comments on your FACs, you then have the right to put in a round of submissions.
So that's the Andrews, that's what I'm calling Mr. Justice Andrews' procedure, yes. That's the one we contend for.
Yeah, absolutely, but you can't equate. It is longer. Mr. Justice Mostyn is right, because you're going to have the stage of, you say 7 days and only 4 pages.
Right, absolutely, and that's the next point I have to deal with, because that is the difference, but it's the only difference between the two procedures. But, and this is an important but, the procedure adopted by the CQC. No, I'm sorry, I'm so sorry. I'm going to come back to that point. That's as a separate point under ground 2. My lord is right. The difference is that under Mr. Justice Andrews' procedure, the reviewer will have to conduct his or her review with or in the light of whatever representations have been made by the service provider, which is something that he or she won't have available under the CQC's procedure. But that's precisely why Mr. Justice Andrews held that there should be this opportunity, namely so that a service provider who has a grievance about the response has an opportunity to ask for that response to be reviewed. And if the CQC put down timescales, and I've said this already, as to the period of time in which such a review must be requested, and the extent of any written representations to go with the request. We can't be talking about a very long extension of the time to be taken by the review as between the two procedures. And if your lordships are with me to the extent that you accept that there is a benefit to a service provider from the opportunity to request such a review, and I've shown you what happened in this case in terms of the report then being amended to incorporate further changes which were accepted by the CQC, then it's only right that the reviewer, independent reviewer, should carry out his or her review with the benefit of whatever representations the service provider wants to make.
Ask you just on that specific
Yes.
point, really whether the duty of fairness requires this additional step. Sometimes it might be sensible, it might be desirable, but if it's required, then of course it's got to be a fair process, and you may say, I'm happy with 7 days at the moment. Forensically, someone will then come back and say 14 days. We've seen how long the FACs can get to witness this case. And also, you end up in a situation where some people will simply not accept, and maybe they're right not to accept, the judgment of the CQC. Witness your case. You pointed out, well, they've made these minor changes, but we've still got a judicial review on the 28th of March. And all this is another very expensive step to be taken when the two sides are going to fight anyway.
Well, Lord, in most cases, the two sides won't be fighting anyway. In almost every case, the only issue will be whether the CQC have corrected the factual inaccuracies or corrected the impression of deficiencies set out in the report. Remember, Mr. Justice Andrews uses a number of different examples of what the complaint might be. But Lord, it's difficult to see that, and indeed the authorities are relatively slim in terms of cases which have actually got to court where judicial review proceedings have been brought. And Mr. Justice Andrews' point was that, and indeed perhaps her point is that that's what the court should encourage by imposing this additional layer of review. So, Lord, we're talking about a very modest extension of time for the reviewer to review the FAC response. As I say, there may need to be no review at all if no review is requested. So what currently happens is that every response is reviewed independently when in draft, every single one. Whereas if the procedure we contend for is adopted, then there may be only a few reviews, because they won't be necessary unless requested. And then I think I've answered the other point made by Mr. Justice Mostyn, which was time is of the essence, and to follow Mrs. Justice Andrews' procedure would involve unnecessary delay. And I think I covered all that in my response, my submissions on the first point. And Lords and Milady, I have some submissions to make as to why the review that Mrs. Andrews has said should apply is of benefit to service providers. And I sought to illustrate that by showing your Lordships the covering letter from the CQC, which shows that in the light of further representations made to it following the service of the final response and report, they accepted that changes needed to be made to the report. And in a sense, I can't do much better than that to support the proposition that I make, that there is a real benefit to service providers to having the opportunity to ask for a review of the response and at that stage. And it's of little comfort to them that there should have been some independent review in the course of the drafting of the response, because they're deprived of any opportunity in that process that they would otherwise have if they can ask for a review following service of the response, namely to explain why they say that the response doesn't adequately meet their earlier criticisms. So, my Lords, that concludes all I wanted to say on ground 1. Can I then move to ground 2? This concerns a particular aspect of what was ground 5, as set out in paragraph 19 of our skeleton argument for the hearing below. The point arises, and the reference is paragraph 19, page 54 of the supplementary bundle. I don't propose to turn it up because I can indicate what the point is quite simply. The point arises because of when we turn now from the respondent's procedure to its policy, the point arises because of the policy which the respondent has adopted, which is to base its judgments and ratings. I'm just going to pause there. Judgments are, as the word suggests, what they set out in their report as to how they judge the service provided by the service provider. And their ratings, apologies if the court is already only too well aware of what the ratings are, but they're the ratings of inadequate, poor, good, requires improvement, good, and so on. So those are the ratings. Obviously those matter most of all to the service provider. So that's what is meant by, that's what I mean by judgments and ratings. So the policy that the respondent has adopted is to base its judgments and ratings solely on what its inspectors find at their inspection, and to refuse to take into account, when arriving at those judgments and ratings, any remedial steps which the service provider may have taken in response to concerns raised by the inspectors during the course of their inspection. Now, Mr. Justice Mostyn, if I may take you to his judgment.
Well, just before we look at the judgment, can you just summarise for me what is the source of the legal duty that you are relying upon here? Because the complaint is, and I'm looking at your grounds of appeal where it's nice and clearly and succinctly articulated, is that it's unfair and thus unlawful of the respondent not to take into account in its final report and its rating of the appellant services the remedial steps taken by the appellant since the inspection.
Yes.
So it follows that you say there's a legal duty on the appellant to take into account in the report and in the ratings remedial steps since inspection. So where is the source of that legal duty?
The duty to act fairly.
But why is it unfair if it be the fact that on the inspection day the service was inadequate, even if subsequently there's been remedial steps?
Well, it's unfair because if, as was the case here, and may well be the case elsewhere, several months passed by between the date of the inspection and the date of the report. It's unfair if the report then criticises the service provider and arrives at judgments which are based solely on the service as they found it to be when they inspected it, and if the report then makes ratings based upon that, if changes have been made in the meantime which no longer render, for example, the service inadequate in terms of safety. And that's unfair because what the...
I'm still struggling to understand this. So, on the inspection date, the service is inadequate, let us suppose, because it is unsafe. Just take that as a hypothetical. Why is it unlawful for the report to state that just because maybe months later steps have been taken to provide a safe service?
Well, it would not be unlawful to state that, provided that the report went on to state, since then changes have been made, and those changes lead us to conclude that the service is no longer unsafe in terms of, inadequate in terms of safety.
But then it no longer is a report of what was found on the inspection date.
No, that doesn't have to be solely a report on what was found on the inspection date. The relevant statutory provision does not restrict in any way the report in that way.
Well,
relevant
section 61(2)(a) requires the Commission to prepare a report on the matters inspected.
Yes.
Well, that's pretty clear, isn't it?
With great respect, no, it's not. It doesn't. The matters inspected, obviously the report will address what it found, and no complaint can be made of that. But the matters inspected will be, well, we inspected the service for safety, effective leadership, and so on. And there's nothing in section 61, that in any way restricts the report from taking into account any changes that have been made since.
Well, it's not an argument that Mrs. Justice Andrews was attracted to, is it? Because you can see from her judgment in SSP that she rejected points like that.
Well, can we just see what she said? Maybe?
Yeah, so paragraph 46.
Yes,
She's pretty
46.
clearly rejecting that approach, and
Yes, what?
she rejects it in 49 as well.
Yes, what she said in 46 was that the regulator is not bound. This is the last, I pick it up in the last line.
Well, can we start with the first sentence? I accept the report reflects and can only reflect what was found at the time of the visit. and
Yes.
not later.
Yes.
I mean, that's kind of crystal clear, isn't it?
Yes.
Whereas you're saying that that's just wrong in law.
Yeah, I'm saying that is wrong in law because it doesn't sufficiently apply the principle of fairness.
Okay.
I mean, can I just try and make good that submission by showing you some further documents? Because one of the curiosities about this case is that what the CQC does is to record any changes that have been made since the inspection, changes that have been made in the light of the concerns expressed by the inspectors during the course of the inspection. Can I ask you to go to the supplementary bundle, please? At page 367. Now, by way of background to this document, what happens during these inspections is that as the inspection proceeds, the inspectors may express concerns about the service to the representatives of the service provider who are taking part and assisting the inspectors in their inspection. And the day after this inspection took place, the 18th, inspection 17th of May, the day after the 18th of May, the lead inspector, Ms. Gwyndy, sent the document your lordships and my lady find at 367, the online services feedback meeting template, to the appellant. And your lordship will see the details of the inspection team in the right hand column on page 367, and then left hand column, feedback given to, areas to raise feedback. And then if you go over to page 368, you will find in the left hand column concerns raised by the CQC team. And I don't need to read them out. In the right-hand column, the appellant set out its response. This was a response it was being invited to set out by the CQC in response to the concerns they'd raised in the inspection the day before. And that response continues through to page 370. And then at page 371, your lordships and my lady will find a disclaimer. This written summary is provisional. The inspection report may refer to additional matters. Further analysis and consideration of the available evidence will be undertaken before our final judgments and ratings are made. So pausing there, it would seem that the steps, because the response did include reference to accepting this, accepting that. We've made changes to the system. This has now been corrected. We're reviewing these questions. So it would seem from the disclaimer that it was intended that those responses should be taken into account in the course of the making of the judgments and the ratings. Why else ask for that material? One asks rhetorically. What's the point of the exercise that the CQC was engaged in if it was going then to ignore the responses provided by the appellant. And the same point arises in relation to the covering letter to the draft report, page 390 in the same bundle, dated 29th of June 2022. Where, as Gwyndy says in the first paragraph, following our recent inspection, we enclose our draft inspection report. This is your opportunity to tell us about any information in the report that is factually incorrect, or where you think we should consider additional information to inform our judgment of your service. The name of the page, when to respond. Once you've received the email with the draft report, you have 10 working days to submit the points you wish to make, any extra supporting information that you think is essential for us to consider that may influence the content of the report and or our judgments. Again, I ask rhetorically, what was the point of inviting the appellant to submit such further supporting information if it was then to be ignored, as it is, deliberately, when the CQC arrives at its judgments and therefore its ratings? So, in answer to my Lord Justice Arnold, my first response is, well, the CQC itself invited the appellant to submit further material, evidence, information, whatever you may care to call it, and to do so on the basis that it would be taken into account. Indeed, in this letter that we've just seen, taken into account in relation to the CQC formulating the contents of the report and or its judgments.
But is that an invitation to submit evidence about what you've done since the criticisms were made?
Well, it's certainly not an invitation not to.
I see.
And indeed, my lady, what's the point of the first document that I showed you, which invited a response from the service provider to the concerns that have been expressed on the day of the inspection, if there was no intention to...
But isn't this precisely the point Mrs. Justice Andrews was making? So, take one of the examples in the SSP case, whether or not there was a policy for dealing with old people. The inspector had asked the practice manager, and he said, no, don't think so, never heard of it. And then what the service provider wanted to do was to submit evidence that yes, there was a policy in existence.
Well, Mary, that's quite, with respect, that's a different point, because that was a point that simply went to the simple factual question: was there or was there not a policy in existence?
Yeah.
This is a much more detailed.
But it's further evidence. The point is, the existence of the policy, according to the service provider, was shown by a piece of paper of a policy, which the inspecting team had not seen because the practice manager didn't know about it.
But had existed on the date of the
Yes,
inspection.
and that's the particular factual error that arose in, or one of the factual.
Right. So why aren't these questions directed to that sort of evidence?
Well, they don't say they are, lady.
I see. Okay.
Yes, but you have to put that fairly in the factual context, that it's a published policy of the CQC to rate on the date of the inspection, and your client would have known that.
Well, but what in that case? Well, two further answers to my two answers to my Lord's question.
Of course.
The first is, what then is the point of this feedback exercise? I ask rhetorically.
Well, isn't it to discharge the duty of fairness that you trace back to 1974?
But if they're not, if the
But in relation to the date of the inspection, because I may go in, I may think wholly wrongly that what was there was needed improvement, and you can point out that actually, by reference to a whole series of documents, which I didn't bother to ask you about, I didn't need improvement. There's nothing that says by the way, if you realise that you need to improve and then adopt improvements afterwards and accept this as a fair comment, you now have the opportunity to make us change the report. Or is there?
Well, I mean, the first point to make is that the feedback meeting template does not anywhere say we're only interested in any feedback you can give as to what the position was as at yesterday.
Well, it might be thought in the light of published policy. It was so obvious it didn't need to be said.
Well, if it was that obvious, one asks why the disclaimer at the end on page 371 should have said what it did. Or maybe that was so obvious they didn't need to say that they were.
Well, that is saying that we may change our opinion. At the moment, we rank you as inadequate. When you've sent in further material, or when someone more senior has read through and realised that I've misunderstood your answers.
Well, my second answer, my second response is this. What the CQC in fact does is to include, and certainly what it did in this case, is to include in the final report the changes that have been made to the procedure, to the service, the remedial steps, as I've called them hitherto, in the light of the concerns raised during the inspection. And the learned friends helpfully set those out in their shows beginning at the top of page 37. And if you were to look at the report, and I don't invite you to do so because it isn't necessary to do so, you will find that these passages have been included in it. So what the CQC have done is to invite comments from the, invite a response from the service provider to the concerns raised. They're obviously interested in those responses, not least because they have included them in the final report. But what they haven't done, and what we complain of as being manifestly unfair, is to refer to them in the final report, but not to take them into account when arriving at the most critical part of the exercise, namely their judgments and their rating.
So the respondent's case is crisply summarised in paragraph 78, which is just after the quotes that you've just referred to, where they say the approach was entirely in line with CQC's published policy. Information provided as to remedial steps was referred to in the report as appropriate. However, the ratings and judgment were based on the evidence gathered and provided by the appellant as to the service at the time of inspection. Where's the error of law in that?
Because it's unfair to publish a report that will be seen by a large range of interested persons, stakeholders, insurers, all sorts of people. Publish a report that, as at the date that the report is published, is no longer a fair and accurate representation of the service being provided by the service provider.
So you say it's unfair to state truthfully that a service is unsafe in January, even if it's been made safe in March.
No, that's not quite what I said. When I entirely accept that they're entitled to say that when we inspected on the 17th of May, the service was unsafe or not good enough, whatever the expression is, in the following respects. But what's unfair is not to go on. Well, they then go on and identify changes that have been made to the service since then. But what is unfair is not then to take those changes into account and to say in their report, if it be the case, in the light of the changes that we've set out, we do not now consider the service to be
So what
inadequate.
further period has the CQC, by implication, got to take into account in looking at remedial steps and seeing whether or not to revise its initial rating?
Milady, it's a moving target. I mean,
Yeah.
obviously, if the report, if there's very little response to the feedback form, and the report is published soon afterwards, then no doubt the changes won't have been made, or there may have been no changes suggested.
So this could be another iterative process that could go on for months.
Well, this 5 months elapsed in this case between the inspection and the report and the threat of publishing.
How do you identify a cut-off point?
Well, it's not, in our submission, it's not necessary to do so. These are, the CQC is the regulator, and one would expect the regulator to do its best to work constructively with those whom it regulates. And that this is an example, we suggest, of constructive working relationship between the two. And it's quite unnecessary for any cut-off point to be laid down. The simple point is that if the CQC is satisfied by the time it reaches it arrives at its judgment and its ratings, that changes have been made, and that those changes turn what would otherwise have been an unsafe procedure or service into a safe service. It's unfair and irrational as well not to say so.
So it's a duty to report on the state of affairs as at the date when the report is published,
Correct.
or a date shortly before the report is published, rather than the duty to report on the matters inspected.
To report on the state of affairs as at when the CQC sit down and say, right, the lead inspector presumably sits down and says, right, how do I judge this service? How am I going to rate it?
So that's an arbitrary date. So the inspector could just say, right, well, I've heard a bit about remedial steps.
Well,
I'm going to write the report now.
Milady, can I answer your ladyship's question in this way? The report sets out the changes that have been made. So there was a date by which the lead inspector was able to say to herself when she drafted the report, okay, I'm going to record in the report the changes that have been made since the inspection. So there's no difficulty for her in identifying a date. It was the date when she drafted the report.
Yes, but if she's then required to evaluate whether or not those changes change the ratings,
Yes.
there's a lot more further work involved, isn't there? She can't just snap her fingers and go, oh, these changes, yes, they're okay. You've got to work out whether the changes deal with the concerns and the extent to which they deal with concerns and how that affects the mark.
Well, lady, is there a problem about CQC having to carry out a bit more further work in order to?
Well, so then the inspector does a bit more work, and then the service provider writes in and says, oh, by the way, last week we made a further change. Where does it end?
Lady, that wasn't a problem in this case.
All right.
And if it wasn't a problem in this case, then I respectfully suggest it's unlikely to be a problem in most other cases. And it's always open to the CQC to say, well, I'm sorry, you're too late, I've written the report, and there it is. But that's the sort of dialogue that one would expect between a regulator and a regulated body, with great respect.
Very good. I see the time. We will break there. Would I be right in thinking that there's not a lot more to be said on this ground?
Not a lot more to be said, no more.
All right. Well, we'll resume at 5 past.